Your Honour, my name is Jack Dion, and today I appear as counsel for the accused, Mr. Marshall Ike. Your Honour, pursuant to Section 590AA, subsection 2E of the Criminal Code, an application is made to the court to exclude evidence brought forth against my client by the prosecution. I submit to the court that the evidence regarding admissions by my client in relation to the prosecution's 85 charges were obtained improperly by the law enforcement authorities. It is submitted to the court that through this improper action, the evidence in question be rendered inadmissible in the interests of legislative and public policies. It is primarily noted that Marshall is of Torres Strait Islander descent, therefore requiring specific statutory exemptions and methods of assistance which are unique to the cultural heritage of the people. Your Honour, it is submitted to the court that the cultural heritage of the accused was recklessly disregarded in order to obtain the prosecution's evidence. The accused is a mere 14 years of age and has likely been subjected to Indigenous cultural actions his entire life. Upon questioning the accused, the law enforcement officer posed direct questions to the youth in regards to his actions, which were answered in a manner beneficial to the prosecution. However, the High Court case of Crown and Lee recognises that where there exists damning evidence, if it is unreliable, it will be found inadmissible. I invite Your Honour to recognise gratuitous concurrence, which is a recognised occurrence primarily within people of Indigenous heritage. This phenomenon highlights a tendency of Indigenous people to answer direct questioning by a superior, especially where said person is in a vulnerable state, in a manner which is done so with disregard of their own beliefs in their actions, often fabricating scenarios alternate to the truth. It is argued that this is the case in this circumstance, and that judgment is passed rendering the admissions by the accused inadmissible. Such a conclusion is supported in the Queensland case of Purcell and Vanados, where the learned Justice Ambrose confirmed that, in situations where there exists a cross-cultural encounter, evidence provided can be recognised as unreliable. The court has the ability to exclude such material, as outlined in Section 130 of the Evidence Act, and it is recommended that such an exclusion is performed. It is further presented to the court that the law enforcement officers who arrested the accused callously disregarded public policy, which is designed to both assist the accused and curb illegal activities on behalf of law enforcement officials. It is first noted that, upon the accused's arrest, there was a failure to identify the relevant legal aid authorities that the accused had been arrested. This is identified in legislature at Section 420, subsection 2B of the Police Powers and Responsibilities Act, which identifies further responsibilities in this regard, chiefly that, due to the accused's age, there is a requirement of notification of a support person. This is only relevant where notification is practicable, which in the current circumstances will be the case. In passing, it is further recognised that Mary, the support person provided to the accused, was a support worker, not a member of legal aid as is required under Section 420, subsection 4B. Adding to this contravention, it is recognised under Section 420, subsection 4B, that the relevant legal aid support is required to be present during any questioning of the accused, which in this circumstance was not the case. There also further exists a contravention of public policy, which identifies, under Section 431 of the Police Powers Act, that a prudent officer is required to caution the accused prior to any form of questioning, which under Schedule 2, Section 26 of the Act, includes identifying that the accused has a right to silence. Further procedural contraventions are also recognised to have occurred at the police station. Alongside the aforementioned failure of the legal enforcement officers to recognise the cultural phenomenon of gratuitous concurrence on behalf of the accused, it is recognised that the officers failed to provide the accused with information that he had the opportunity to phone his family or make further contact with any relevant persons to the accused. This is a recognised right of the detained under Section 418, subsection A and B of the Police Powers Act. It is further noted that, upon listening to the audio recording of the interview, that a number of parts are inaudible. This is a clear breach of Section 436, subsections 2 and 4 of the Police Powers Act. It is further recognised that there also appears to be a failure on behalf of the prosecution to supply a written confession from the accused, which is recognised under Section 437, subsection 3 of the Act, to be a requirement when reasonably practicable, which it is argued to be so in this regard. Your Honour, in applying the 5 factors recognised in Bunning and Cross by the learned Justices Stephen and Aiken, to the aforementioned procedural flaws, there is support of the discretion to exclude evidence obtained by the prosecution. It is unlikely that the prosecution could argue genuine mistake, as the actions of a prudent officer in this regard would not likely result in so many procedural flaws, and there are no stipulations by the prosecution which suggest that there was a clear reason for such procedural flaws, which includes the gravity of the charges. Therefore, use of such evidence against the accused would only be described as being unfair. In summary, Your Honour, it is concluded that the discretion to exclude the evidence of the accused confession is fair, in line with aforementioned legislative and public policies. Thank you, Your Honour.